everyone, and welcome to another episode of Legal Ethics in a New York Minute. I'm your host, Kaylin Whittingham. I'm so happy to be here with you today on another episode where we share tips to stay on track and traps to avoid. Today, we will be discussing escrow accounts. We're going to be talking about the 5 do's of escrows and the 5 don'ts of escrow accounts. This is part 1 of a 2-parts episode. Our second episode will be titled Misuse and Misconceptions Surrounding Escrow Accounts. So let's start off with the 5 do's for escrow accounts. Number 1, keep your escrow accounts separate from your business and personal account. I can't emphasize that enough. If you are using your escrow account as your business account or your personal account, it is a misuse of the escrow account. And that is something that you should not do. So please remember to keep your escrow accounts separate. All right. Number 2, properly label your escrow account. Now, under the rules of professional conduct, the rules have actually specified, Rule 1.15b specifies exactly how you should title your escrow accounts. Here are 3 examples: attorney special account, attorney trust account, or attorney escrow account. So any one of those titles will do and will be appropriate for your escrow account. It is not enough for you to say Law Office of Tim Jones. That is not sufficient. So remember, properly label your escrow accounts. And the number 3 thing that you should be doing is promptly delivering your client and third-party funds and property when requested. Now, what does promptly mean? Well, it can be more than a day, more than a week, but it's not a month, it's not 3 months, it's not 6 months. Unless you have some legitimate reason for holding your client funds for that period of time, you should promptly turn it over to your client or third parties whenever it is requested. Number 4, maintain your bookkeeping records for 7 years. Now, in New York, we don't have a time period where we need to maintain our client files per se. However, for bookkeeping records, especially those pertaining to your escrow account, we are required to maintain them for 7 years. It's not just your escrow. There are other records that you need to maintain. And if you look in Rule 1.15, it will be listed there. And number 5, this is important. Before signing your biannual registration, which we all do every 2 years, be sure to read Rule 1.15 and read it carefully because you want to make sure that you are in compliance with the rules. In the first and second department, you are affirming that you have read Rule 1.15 and you are in compliance with the rules. So before you sign that you have done so, a refresher every 2 years will not hurt. Pick it up, read it before you affirm that you've done so and you're in compliance. Because if you are not in compliance, that is a violation of the rules and could form the basis of a disciplinary charge should there be an investigation in the future. Okay, let's move on now to the 5 don'ts of escrow accounts. Number 1, do not issue check to cash. You'd be surprised how many attorneys don't know this. You should not be issuing a check to cash. It must be made out to a name payee. So if you're going to continue to issue checks, if you have an escrow account, you must issue that check to a name payee and not to cash. Number 2, do not allow a non-attorney, including an attorney in another state that's not licensed in New York, to be a signatory on your escrow account. And don't allow your wife, who may be your bookkeeper, to do that either. Although she could be a signatory on your personal or your business account, it is not allowed on your escrow account unless she is also, or he, in the case of spouse, that the female, it's the attorney, unless the other party, the other spouse, is also an attorney in New York, you're not allowed to have that person be a signatory on your account. So that is something that comes up very frequently, frequent enough for us to really emphasize it. You cannot have a non-attorney, bookkeeper, accountant, whatever you want to label them, be a signatory on your escrow account. Number 3, do not leave your legal fees in your escrow account. Now, New York is very unique in this way. We are not required under the rules to put our retainer in our escrow account until they're earned. We are allowed to, but we're not required to. So in New York, you can actually put your retainer in your business account, right? The only thing is, if you put it in an account that's your business or your personal, you must be able to refund unearned fees. So you can put it all in your business account, and that's okay. That does not mean, however, that all those funds have been earned. It simply means that you can host them there for the time until they're earned, and that will not be a violation of the rules in New York. This is very different from many states that requires that you put your unearned fees in your escrow. That's not the rule in New York. You can do it, as I've said before. And if you do so, you must promptly withdraw those fees when they are earned. So again, do not leave your legal fees in your escrow account. Number 4, and this should have probably been number 1, but I think we all know it, but it's worth repeating because each year attorneys still get disciplined for this. We are not allowed to misappropriate client or third-party funds, right? Even if it's not the client, and let's say you have gotten a litigation advance from a third party, and you should have had that money in your escrow when you got the settlement on behalf of the client. If you use that money, that's also a misappropriation of funds. That would be a misappropriation of third-party funds. Although they are not the client, that is still a violation of the rules. So remember, you can't do that. 5th, and the final one for today, do not rely on your bankers for answers to what you should or should not do as it relates to escrow accounts. Yes, some bankers do know the answer, but many don't, and they will tell you that they do. I had that experience personally. So the onus is on you. It is our responsibility to know the rules. It is not an excuse to say the banker told you to do A or B. You must know the rules. The onus is on you. So do not rely on a banker to tell you what to do when it comes to your escrow accounts. Well, that's it for today. 5 escrow do's and 5 escrow don'ts. If you like what you've heard, like, share, comment, send us questions. We'll be happy to answer. And until next time, I'm your host, Kaylin Whittingham, signing off.